just unprecedented times for everyone. And there's just been so much change, specifically in the HR space around legislation and, moving to a remote workforce and leading our teams in this kind of different crisis time is really challenging. So we're excited to have Linda with us. She's a part of our OC Nonprofit CEO Forum, and we got connected with her. And Linda has over 30 years of kind of HR related experience and is the president and founder of Ethos Human Capital Solutions. They focus on recruiting, consulting, training, organizational development. She's known as a people problem solver, and specifically Linda helps business leaders get the right people, systems, and culture in place to achieve their goals. So she has a wide variety of experience. She's a senior professional in human resources and has her MBA from Webster University. So we're excited to have Linda. This is definitely her wheelhouse to kind of catch us up to speed with HR issues related to COVID. So I'm going to go ahead and pass it off to her. And then again, if you have any questions, just go ahead and relay them in the chat box.
Thanks so much, Kevin, and thanks for inviting me to present today. Hi, everybody. Hopefully everybody is staying well. I wish I was coming to you from sunny Hawaii, but unfortunately I'm in rainy Southern California like the rest of you. You'll notice in the chat box, I already typed in a URL. It's a tiny URL that you can use to download the slides. It's also on the last slide of my presentation, and I think on the agenda slide as well. So if you want to download the slides, go ahead and just click on that link or copy and paste it. As Kevin said, we're in unprecedented times, and so I don't usually date the title page of my presentations, but I felt compelled to because I will tell you, what I tell you now could change again. Just with the Families First Coronavirus Relief Act, the FFCRA, which we're going to talk about, DOL, the Department of Labor, issued temporary regulations, and we're expecting the final ones today. From the time the bill was passed to the time the temporary regulations were issued, changes were made, and I expect some changes will be made again. So this is very fluid, and what I tell people one day, I may have to call them the next day and say, you know what I said yesterday? Well, guess what? So that does change, so bear with us on that, but I'm going to give you the best information that I have as of right now. So here's the topics we're going to talk about today. And again, as you have questions, I'll sort of stop in each section and ask if there's any questions. So just type them in as we go. And then we'll take questions at the end as well. I can stick around as long as you guys need me to, do my best to answer questions. There again is download the slides. There's the link you can use. So we're going to talk about the different categories of employees, meaning, if you have people working from home, if you have people on furlough, what all those different categories mean, and sort of the rules around each one of those, and then my best guidance for you on what to do with those employees. We've put in a couple what to do if scenarios, and we'll talk about that. Then the FFCRA, as I mentioned before, there's a lot of confusion over this, a lot of questions like, does everybody in California automatically get 80 hours of sick pay? Answer is no, but we'll go through that. And then I'm just put one slide in to talk about the CARES Act at the very end. I know Kevin sent out an email today. I think it was Kevin, sent out an email today. I get a lot of emails these days. Somebody sent out an email with some additional information on it, but I'm just going to touch on it a little bit, and then I'll do my best to answer questions. But again, I'm not a lawyer, I'm not a banker, I'm not a CPA, I'm an HR professional. So that is my wheelhouse, and I'll do my best to answer those questions. So when I think about categories of employees, here's how I sort of break them down. Some of you probably have business as usual. People are working at your normal work location. Some of you may have sent employees home to work, so we'll talk about that. Some of you may have employees who are working reduced hours. You can't keep them busy full time, whether that's at the office or at home. And then a lot of confusion around what's the difference between furloughed and layoff. So we'll talk about that as well. So let's jump into working at the office. So first and foremost, for your organization to remain open, it must fall under the critical infrastructure industries list that California has produced. It's very similar to the federal list, but you need to take a look to make sure. Now, last night I pulled off some of the list that I thought may or may not, since I don't know the organizations that are on here, apply. So for example, if you are conducting community-based public health functions, that would allow you to continue to operate. If you're providing support to vulnerable populations to ensure their health and well-being, that would allow you to continue to operate. If you're working in the food space, if you're providing food or healthcare, anything like that, that would allow you to continue to operate. But if you don't fall into a category that's on this list, the link that I provided here, then you are not allowed to have employees working at your office, okay? Even if you fall on this list, you need to consider whether or not all of those employees need to work. This is such a critical time. I was reading last night online that California is not even expected to peak in terms of the number of cases of COVID-19 until 3 weeks from now. Okay, so it's still really critical that we keep as many people at home or out of the office environment as possible to try to control any sort of outbreak further than what we already have. So if you're working at the office, of course, there's some common sense guidelines. I don't think we need to go into a lot of detail here. You want to make sure you're practicing physical distancing, proper hygiene, washing your hands, all those different things. Sanitizing the work area is really critical. And then one of the things people don't often think about is maybe you want to post signage around the office to remind people to keep their distance from each other, but also restrict sort of where they go and how many people can go at a time. So for example, if you have a break room, a conference room, even in people's offices, we've got clients that are posting signage to limit the number of people in any common area at a given time. We have a client, for example, that tells everybody not to like walk to somebody else's cubicle to communicate with them. They're using like an internal messaging system, email, or picking up the phone and calling them. It's really different for most people. The beauty of working together in the office, you can, just go down the hall and ask somebody a question. But in these times, you want to try to limit as much physical contact as possible. The other thing to think about is providing what we're calling bust a barricade document. That was given to us by one of our clients. We like the title, so we stuck with it. It should go on an organizational letterhead, but the purpose of the document is for people to come and go as they please. We're hearing, especially in Northern California, people are being stopped by the police. I don't know if the National Guard's involved yet, but you can expect that will happen as well. So if a lot of people are out and about traveling, they may be stopped and asked like, hey, where are you going? Why aren't you at home? And so we just suggest you put on your organization's letterhead a letter from the CEO or executive director saying, hey, we're considered a critical industry or essential function because this is what we do as per the governor's list, and this employee works at this organization and must come to the office. And then just advise your employee to just keep it with them when they're traveling to and from work, just on the off chance they do get stopped, because we have had reports of that. All right, if you're working remotely, have employees work remotely, we really recommend that you have them sign a telecommuting agreement. A telecommuting agreement is really just to make sure that everybody understands the rules of engagement. It's not, you're not having them telecommute because, it's easier for childcare or because, of a lot of different reasons. It's really because that's how they need to work right now. So the other thing to keep in mind is California does require you to reimburse employees for all reasonable and necessary expenses incurred in the performance of their duties. So if they can come to the office and work, and they can use your computer and your internet and your phone system and your electricity and all of those things, no problem. But if you're telling them to go home to work, all of a sudden they're going to be using all of those things that they're paying for. And what you need to do is offer them some sort of subsidy toward that. It doesn't have to be a lot. The law doesn't say how much, doesn't even say how to calculate it. It just says you need to pay them for their expenses. So like in my particular company, we have always worked out of our homes because we're usually at a company site. So I pay my employees $50 a month, our full-time employees, and our part-time employees $25 a month. And that's because they're using their own laptops and they're using their internet and they're using their cell phones. Okay, so that's just what we came up with, and that's what we're doing. If they have additional expenses, like maybe they need to buy a ream of paper, then they put it on an expense report at the end of the month. So just think about that. And there's, again, no real answer to how much that should be. It's just something that you work out with your employees, and it can just be for a period of time where they're working from home. Okay. The other thing that's super important is that you make sure that they realize that all wage and hour laws are still in effect, meaning they still have to track their time. Non-exempt employees must show 4 time punches a day. So it's when they started work, when they went to lunch, when they came back from lunch, and when they left at the end of the day. That doesn't change because they're working at home. It may make it a little squishier, if you've allowed them the flexibility. hopefully you've given them in that telecommuting agreement your expectations. You know, do they still have the same set working hours? Is it just that they need to accomplish so much work during the day? However you set it up, just make sure you spell it out so they understand what your expectations are. And I would include some basic wage and hour rules around timekeeping, reminding them to take their meal and break periods, reminding them to take their meal period before the end of their 5th hour. All of those things still apply. And it's really hard when you're working at home. I mean, I'll be surprised if I get out of this without gaining 20 pounds, right? I have food all day long at my fingertips. And so you still want them, though, to take a dedicated meal period, take their 2 10-minute breaks, okay? If you're issuing them equipment to take home, whether that's a printer, a computer, whatever it is, we suggest you use an equipment log to track that, just so you can see by serial number, or however you want to track it, they were issued that computer or that piece of equipment and that they're going to bring it back. Obviously, we recommend that you stay in touch with all of your employees, and you can use great apps like Microsoft Teams, Zoom, Slack, Band. All of those can work, and most of them are free, or if you already have you know, an agreement with like Microsoft, things like that. Um, Something fun to do, and I know that Kevin said that you guys are going to have access to another webinar soon specific to working remotely, but consider doing something fun like scheduling happy hours or coffee breaks together, like when no work is done, just voluntarily, and use Zoom. My birthday was last week. I threw myself a birthday bash on Zoom. I invited my friends and family, and you know, it's not ideal, but it's great. And you just sit around and you chat with people, and you know, share a cup of coffee, have crazy shirt day, whatever you want to do, but just, you know, try to keep people engaged and still feeling like a team when they're working remotely. Okay, you may have some people that are working reduced hours. You want them with the first hour of loss of pay, file for unemployment benefits, okay? They actually do that by going online. And what you should do is give them the website, define. The employee goes and applies online. It works just like every other time anybody's ever applied for unemployment. I'm sure you've all received those forms before. If they put on there that it's a reduction in hours, they're still eligible for benefits even though they're working. Now, depending on how much money they make and how much their benefit would be, it offsets. And so I'll give you an example of that in a second. It offsets, so they may or may not get any additional money from the state, but you want them to get in the system because you don't know what the future holds. So this week you may say, hey, I've got 30 hours for you. Next week it may only be 20. You may have some weeks where they have no hours, and all they need to do is every 2 weeks, I think it is, they go online and they report how many hours they actually worked, and then that way they're already in the system. So as things change, as time goes on, they'll already be there and they can receive their benefits. Now, if you have reduced working hours, one of the things we highly recommend is you consider implementing EDD's work share program. So this is something the employer fills out an application and sends it in. I'm giving you the link right there. It has to affect at least 2 employees and 10% of a workforce, and that can be a unit or the organization overall. It's if you're going to reduce hours and wages between 10 and 60%. Okay, so if it's going to be more than 60%, doesn't matter. If it's less than 10%, you're not eligible for it. It cannot be used as a transition to layoff. So this is just a situation where we say, you know what, we don't need everybody, but in order to avoid layoffs or furloughing anybody, what we're going to do is take everybody down to 30 hours or everyone down to 20 hours a week. And so it's a way everybody shares a little bit in the pain, but the beauty of it is you can avoid in some instances, putting people out of work completely. It also provides a greater benefit to the employee as compared to regular unemployment insurance. So let me give you an example of this. And when I say this is hypothetical, I mean completely hypothetical. People do not understand that the calculation for unemployment insurance actually has not a lot to do with your current amount you're making. They take your base period wages, which right now is 2019. So that's really what they're looking at in order to consider the benefit. So hypothetically, this is what would happen. On the left-hand side, you see if somebody applies for unemployment. Let's say in my hypothetical example, somebody's weekly wages are $1,000 and the hours got reduced by 50%. That means their actual wages are $500. Well, at $1,000 a week, they're going to most likely max out the benefit under unemployment, which is $450 a week. So they'll receive no benefit or very little benefit. They might get $25 or something like that. So on the left-hand side, if somebody goes from $1,000 a week down to $500, they're living on their $500. But look what happens in WorkShare. Same situation, $1,000, now they're making $500, but the employee gets 50% of their usual UI benefit as though they were not working. So they would get 50% of that $450 benefit on top of their wages. So they would be making $725 during that week. So it is a big difference between just regular unemployment and the WorkShare program. Now, there is a little bit of administrative burden on whoever's processing your payroll. There's a form that has to be completed every payroll period to say for all of these employees that are affected, here's how many hours they worked, here's how many wages, what the wages were. But to me, it's a big enough benefit to make it worthwhile. So you can, again, just go to that website or Google EDD WorkShare. It has all the documents there. It'll tell you exactly what to do. There's like a 45 or 50 page pamphlet to show you exactly how to fill out everything if you need it. So I would highly recommend you take a look at that. The other thing, if you're working reduced hours, is think about how it will affect their benefits, if at all, right? So you've got healthcare benefits probably that you're offering. Are they going to continue? Do they have to pay an amount that normally comes out of their paycheck? Things like that. For the most part, the probably answer is yes. What about PTO or vacation accrual? Will they continue to accrue at their regular rate if they're reduced to, say, 20 hours a week? Or are you going to cut that in some way? What about holidays? If a holiday comes along, for most of us, probably, some people might have Good Friday or Easter off, but for most of us, it's probably Memorial Day. Maybe we're back to work by then, maybe we're not. What will happen? Will you pay it? Will you not pay it? Pay it at a lower amount? Think about those things. And then also, again, think about how it affects meals and breaks and any other benefits you may have. If you're going to cut people's hours and they're going to be working fewer than 6 hours, whether at home or at the office, the employee and you can mutually agree to waive the meal period, but use a meal period waiver, because if they work more than 1 minute over 6 hours and they don't take a meal period, then that's a wage and hour violation, and you would owe them a meal period penalty. All right, so let's talk about furlough. Furlough is like, this is how I think of furloughs. Think of it like a leave of absence. For whatever reason, somebody's not going to work for an indefinite period of time, or maybe it's for a specific period of time. But ultimately, your intention is you're going to bring them back to work. So if the furlough will be more than one payroll period, there is a Division of Labor Standards Enforcement, the DLSE in California, who manages wage and hour claims. There is a DLSE opinion letter that says if they're going to be furloughed for more than one payroll period, you must pay out wages and their unused vacation or PTO, just like you would if they were terminated or separated from the company. So just know that. But essentially what you're going to do is tell them they're being furloughed. We actually came up with like a notice to give them that has some explanation. This is what's going to happen to your benefits. This is some resources for you, things like that. Gives them the information to go apply for unemployment. So tell them apply for unemployment immediately. I don't think I mentioned this yet, but because of the state of emergency we're in, the normal 1 week waiting period was waived by the governor when that went into effect. So now they can start collecting unemployment benefits as soon as their claim gets processed, which is happening faster than we originally expected it to be, given the millions of people that have filed. Let employees know how their furlough will affect their benefits. You know, will healthcare continue? Will they accrue vacation? What's going to happen? I would suggest that you take it on a limited period at a time, right? Maybe weekly, maybe 2 weeks, something like that. Don't right now, my advice would be don't say for the entire period of your furlough, we'll continue your benefits, because we don't know how long this is going to last. So we're advising clients to just take it for like the next 2 weeks at a time, or say, hey, through the end of April, this is what we're going to do, and then we'll reevaluate and get back to you. Okay. Communicate with them frequently. You want to make sure that they're staying tethered to the company. That's the beauty of a furlough, is technically they're still employees, right? You don't have to go through the whole onboarding of them again, have them complete all new paperwork, anything like that. You just call them back to work when they're available. And so we say communicate with them weekly if possible. So again, if you have Slack, if you have if you have Band, if you have any of those type of communication materials, if you have personal emails for people, make sure you get those. send out an update via email, but anything just to make sure that they know that you care about them, that you're concerned about them, that this is where the status is with the organization. And then we like to give them tips and resources. Most of you probably know about 211.org, which is just sort of a central organization where you can get a lot of great help for different, it's a community-based organization. We're suggesting to people like, hey, tell your employees about this, because a lot of people don't know about it. And if they need help getting food or with paying rent or anything like that, it's a great place to go. Okay, and then laid off, of course, is meaning that this is a separation from the company. So you're going to treat employees like you would anybody else who's been separated. You're going to give them the notice to employees to change a relationship form. The DE 2320 pamphlet is what tells them how to apply for unemployment, COBRA information if they're on your insurance policy, and then final paycheck, including any unused vacation hours. Obviously, they need to apply for unemployment benefits immediately. And then if you lay off 50 or more people in a 30-day period, hopefully this doesn't happen, you may be subject to the WARN Act, which requires some specific notifications to the employee, but also to the state. So if you have 75 or more employees and you're laying off 50 or more, just know that, and you should seek legal counsel or call an HR consultant for help with that. And I'm going to stop right there, Kevin, to see if there's any questions that I can answer about those categories. And so I can drink the Breakfast of Champions, my Diet Coke.
So far, Linda, we haven't had any specific questions. I'll go ahead and give everyone maybe 30 seconds. If you haven't typed them in yet, go ahead and do that now.
Kevin, was that clear for you on the furlough versus layoff?
Perfect, super clear. I think thinking of it as a leave of absence is a really helpful way.
That's the easiest way I can explain it to people. It's just they're not working for a period of time, but no different really than if they had gone off on pregnancy leave or anything else.
Right. All right, well, let's keep going.
Okay.
If there's any questions, feel free, guys. This is your time, so add those questions as they come up.
Okay, awesome. So a couple of, just a few different things to talk about, just to what to do if. So first of all, you always want to remind employees to stay home or go home if they have symptoms of COVID-19. The CDC is listing dry cough, fever, sore throat, tiredness, difficulty breathing, right? I think everybody knows that at this point, but I just like to point it out again. We are seeing in Orange County where we just got a phone call this morning, as a matter of fact, from one of our clients, not that one of their employees tested positive, but like another person that they came in contact with. It's an electrical company. And so on a job site, somebody from another company that was also there tested positive. So it gets a little tricky when an employee tests positive, but here's my best guidance for you. You need to notify the coworkers that someone tested positive. You cannot identify the employee by name. You want to protect the employee's privacy. They're going to figure it out, to be honest with you, in most small organizations, right? You have 20 people that work in an office together. They're going to know because that person's the one not showing up to work. But you want to protect their confidentiality unless the employee gives you permission to reveal their name. Any information you get from that employee, you want to maintain in a confidential medical file. You want to give the date of the test results to the other employees. So you want to give them some sort of notices that says, we've been informed that one of your coworkers tested positive on, April 6th for COVID-19. That person works in this general area or something like that. They work on the second floor, they work downstairs, they work in the warehouse, they work wherever. And then suggest coworkers who may have been in close contact with them to seek medical guidance. There isn't necessarily guidance that you shut down and everybody go home. Some people would take that approach, and that's fine as well. If you want to have everybody self-quarantine for a period of time, have, sanitize the environment. One of our clients actually does COVID-19 decontamination, so I'm happy to provide that as a resource if you need it. But you want to tell the rest of your employees what's going on, and then obviously need to have heightened awareness for symptoms, okay? That's the best guidance we have. We've had situations also come up where there's like 2 steps removed. This morning we got a phone call from another client where their employee who spends time with his girlfriend, the girlfriend's roommate tested positive. CDC says that like sort of secondary exposure does not warrant quarantine. I'm not exactly sure why, but that's the advice we've gotten from our counsel. So just know that as well. So you have to have sort of direct contact with somebody in order to self-quarantine. That is what he's telling me, but I have not seen that in writing. Okay, so let's talk about the Families First FFCRA. So this went into effect April 1st last week. It's in effect through the end of this year. It applies to organizations with fewer than 500 employees, although you need to count everybody, full-time, part-time, people who are on leave, and also temps. There's two parts to it. There's the emergency paid sick leave, which I'm abbreviating EPSL, and there's the expanded family medical leave. So it took the normal Family Medical Leave Act, which normally applies to 50 employees or more, and it also added an additional benefit for those employees and added a singular benefit to organizations with fewer than 50 employees. Benefits paid out under either one of these two, and we'll talk about what those requirements are, may be reimbursed through tax credits, and I'll just touch on that briefly. You will need to request and maintain documentation for any leave that you pay out. There is a posting requirement, so you want to make sure that you are looking for that poster. It's issued by the Department of Labor. If you just go out and just Google FFCRA poster, you'll find it, and make sure that you post it. Now, if you have employees that are working from home, you can issue it to them electronically. Either you can email it to everybody, or you can post it on a shared drive someplace that they have access to and just direct them to that, okay? Now, there may be exemptions for companies under 50 employees and healthcare workers and emergency responders. I'm going to touch on that briefly at the end as well. Okay, so let's start with the paid sick leave. So the emergency paid sick leave provides up to 80 hours of paid sick leave. This is on top of any benefit you already give. So in California, we know that we already have to give people 24 hours or 3 days of sick leave each year, whichever is greater. There's no minimum tenure for eligibility for the emergency paid sick leave, right? So you could hire somebody tomorrow, and then the next day they could come to you and they could say, hey, you know, I fall under one of the categories we're going to talk about in a second. And so you need to pay me the 80 hours of paid sick leave, and you'd be required to do so, okay? You cannot require them to exhaust other forms of paid leave before they take advantage of this program, okay? So remember, FFCRA is a federal law, so we're scrambling to figure out how does it integrate with California law, but that's what we know so far is it's above and beyond what California already requires you to give, and there's no minimum tenure for eligibility for this type of sick leave. So there are 6 reasons that somebody could take this. I'm going to go through each one separately. I will again remind you today is April 6th because we're expecting that the final guidance or the final regulations from the Department of Labor are going to be issued today. They changed this from the time that the bill was signed to the time that the temporary regulations were issued on April 1st. We'll see if it changes again, but this is what it is as of today, okay? The most important thing to remember is someone is only eligible for this leave if they cannot work but for any of the following reasons, okay? So as an example, let's say your organization doesn't fall under one of the critical essential industries and you have to send everybody home. They're not eligible for this. The reason they're not working is because you don't have work for them because you had to shut down. It's a little bit of circular logic, if you ask me, but because you don't have work for them, they're not eligible for this, okay? So this would be, hey, I've got work for this employee, but they cannot work because of one of these 6 reasons. So that's how you have to sort of think about it. So let's just go through them real quickly. So first one says that the employee is subject to a federal, state, or local quarantine or isolation order for coronavirus. Initially, when the bill was passed, all the guidance said that California's stay-home order did not apply to this one. What changed on April 1st is the temporary regulations expanded the definition to include shelter-in-place and stay-home orders. So in theory, if someone cannot work or telecommute because they're subject to this order, then they would be eligible for the paid sick leave. If you have work for them, then most likely this will not apply. The one category I can say where it may apply is there was guidance given if you're 65 years of age or older or in a higher risk category, then you should stay home. If that's the case, if you have an employee that says, hey, I'm over 65, I don't feel comfortable coming to work, or I'm in a higher risk category, then you may have to offer them the paid sick leave under this first one. Now, if they fall into a higher risk category because of medical, then I would suggest that you get medical documentation from a doctor saying, hey, this person shouldn't work right now because they're at higher risk. We've had that happen with pregnant women, for example, doctors saying, hey, I want you to stay home and self-quarantine because I don't want to take a risk with the baby. Okay, so the second category is the employee is advised by a healthcare provider to self-quarantine. Okay, so again, this must be based on a doctor's belief that the employee has COVID-19, may have COVID-19, or is particularly vulnerable to COVID-19. There should be some sort of documentation, which I'll talk about in a little bit. Self-quarantining, though, must prevent the employee from working. So if a doctor says, hey, Linda, you need to go home and self-quarantine, but I can work from home, again, I'm not eligible for EPSL. It must be because I cannot work due to the fact I'm self-quarantining. The third one is a little bit different. It's a little trickier. And this is where the employee is experiencing symptoms and they sort of say, hey, I have symptoms, and we say, stay home, right? Well, they're only covered for EPSL for the period of time where they're seeking a medical diagnosis. So this is symptoms per the CDC that we already talked about. And the benefit is limited to the time the employee is unable to work while taking affirmative steps to obtain a medical diagnosis, meaning the time that they spend making an appointment, waiting for an appointment, attending an appointment to get a test, waiting for test results, anything like that. During that period of time, they would be eligible, but not necessarily for all 14 days. And just because they choose to self-quarantine doesn't make them eligible for this. It has to be a doctor saying, hey, self-quarantine, okay? And again, if they can work from home, then there's no EPSL. The fourth one is similar to the other ones in that the employee is caring for an individual who's under quarantine or isolation order. It has to be an immediate family member, a roommate, or a similar person that has a relationship that creates that expectation. That's a greater definition than we're used to. Usually it's an immediate family member. So this does say, hey, I have a roommate, for example, that is sick or or needs help and has been ordered by a doctor to self-quarantine, something like that, then that person would stay home with the roommate, and you would be offering them the EPSL under number 4, assuming, again, they can't telecommute and care for the individual at the same time. All right, item number 5 is a little bit different because this is caring for a child whose school or childcare has been closed due to COVID-19. Again, it only applies if the employee needs to and actually is caring for that child and can't telecommute at the same time. So we've had this come up where one of our clients has an employee that reached out to us and said, hey, I've got a 1-year-old and a 5-year-old at home. My husband's working full time. I've been trying to telecommute, but on April 1st, she reached out and said, it's really hard to telecommute and take care of a 1-year-old and 5-year-old at the same time. Okay, so we're working with her right now to find out, is there somebody else that's available that can also help out? Is she the only one in her family that can take care of the kids? Can she work reduced hours? Maybe it's not that she has to just be completely shut down for the foreseeable future, but maybe she could work part-time and care for the children at the same time. Maybe she could work in the evenings once her husband gets home and can take care of the kids. So you can go through all of those different options to see if there's anything there that might work it out for you and for the employee. Only one person can claim full-time EPSL to take care of a kid, and it applies to children under age of 18, although I believe, I couldn't find it yesterday, that DOL says that if somebody is 15, they assume that they can take care of themselves, but I couldn't find it in writing, so let's just go with 18 years, under 18 years of age. The 6th reason, we have no idea what this means, to be honest with you. The employee is experiencing either substantially similar condition. DOL has not offered any guidance what substantially similar condition means, so got nothing for you on that one. Okay, let's talk about documentation for the EPSL. So for number 1, if somebody is going to, like somebody's 65 or older and comes to you and says, hey, the stay-home order applies to me, I'm 65, I shouldn't be working, then you would just need to make note of the government entity that issued the order to which the employee is subject. I would create like a sick leave request form. We're going to talk about the leave of absence form in a second, but a sick leave request form under EPSL asks them very specifically to tell you, which rule it is that they're seeking coverage under, and then provide the appropriate documentation. So if it's number 2 or number 3, for example, then you're going to want the name of the healthcare provider. Number 4, again, if they're staying home to care for somebody under an order, then you want that order, or if it's due to someone being diagnosed or needing help because they have COVID-19, then you're going to want the healthcare provider that diagnosed that person. And then number 5, you're going to want the name of the child, the name of the school or childcare that closed, and then a statement from the employee representing that nobody else can take care of the child. Okay, this is paid sick leave, as we talked about. So if somebody comes to you and they're seeking paid sick leave for themselves, let's think of it that way. They're sick, they're 65 or older, they're trying to get a medical diagnosis, then they have to be paid their regular rate of pay up to $511 per day, $51.10 in aggregate, okay? I included a link here to the DLC website where it discusses how to calculate overtime and use the regular rate of pay. If you're not familiar with that phrase, please go to that link and read it, because it's not just their base rate. You have to fold in commissions, bonuses, other calculations as well. Not everybody is familiar with that, and it's super critical that you are. If you are taking care of somebody else, so reasons 4 through 6, you must be paid 2/3 of the regular rate of pay up to $200 per day or $2,000 in aggregate, okay? If the person is part-time or doesn't have a set schedule, or they're commission only, probably doesn't apply to anybody on this call, but we have clients like that, then you wanna see the regulations, because they have other rules for how to calculate those wages. Okay, Kevin, I'm gonna stop right there again to see if there's any questions about the emergency paid sick leave.
There wasn't any questions about emergency paid sick leave, but we did have a couple going back.
Okay.
Um, the first one was, I think it was talking about during the different categories of employees, are part-time employees treated differently than full-time? You might need a little more context in that, but that was the question.
Yeah, I'm not sure like what that exactly pertained to. So I'll just take a wild stab, okay? No, really not. The benefit for unemployment will be different. Um, I can think about that. But in terms of furloughing them, having them telecommute, anything like that, you would just treat them like everybody else.
Yep. Okay, and then someone asked, where can we get the documentation, or the decontamination suggestions?
In terms of how to decontaminate, or like my client who does that?
Probably your client contact.
Okay. Yeah, you can just email me, linda@ethoshcs.com. I'm happy to do an email introduction. They're in Santa Fe Springs, but they go every place. They do hazardous materials remediation work as it is, but they have developed now a specialty in the COVID-19 decontamination. So I'm happy to share that information with you. The company's name is Quality Environmental, but we can give you the direct contact.
Perfect.
Hey, anything else?
And then a few people had said that the direct link for the slides isn't working. I checked it as well. It wasn't working either. It was just
Huh,
linked to a Twitter page.
that's weird. Huh,
Yeah. Is there any way we can
okay.
try and drop that link real quick while we pause?
Um, you know what? I can email it out to everybody, but that's really bizarre because I tested it also last night, so I'm not sure. Um, you're talking about for the slides?
Correct.
Yeah. Okay. So I'll send you the slides afterwards, Kevin. Is that going to work? Is that okay?
Yeah, and I can email it out to everybody.
Yeah. Okay. Yeah. Sorry about that. I don't know what happened. That's weird.
No worries.
Okay. All right. So, okay, let's continue. How are we doing on time? We're still good on time? Okay. So EFMLA, so Emergency or Expanded Family Medical Leave Act. So this is where the employer must provide up to 12 weeks of paid job protected leave. It does not give currently FMLA covered employees an additional 12 weeks, okay? So this law is a little confusing because typically FMLA applies if you have 50 or more employees, and it still does, but it expanded Family Medical Leave Act in that for those people who are already covered by FMLA, it adds another reason they can take it. And for employees or organizations with fewer than 50 employees, this is the one reason they would be able to take the expanded FMLA, okay? So if somebody, let's say somebody was pregnant and they were out of work, January through March or something like that. Now they come to you and they say, hey, I want to take the expanded FMLA to care for a kid who's, home from school or something like that, but they've already exhausted their FMLA, they would not be entitled to it. Okay. So just know that, or if if they already use 6 weeks out of the 12, they would have 6 weeks left. Okay. So just keep that in mind. Now, for anybody who wasn't already eligible for FMLA, then obviously this is going to be 12 weeks for them, but it does not give them rights to other types of leaves if they're just now becoming eligible because of this. Okay. Intermittent leave may be taken if the employer allows it. There's only one reason that somebody can take the expanded FMLA. This expansion was only if the employee has to stay home and cannot telecommute because they have to care for a child because the school closed. Now, I would think right now we would all know who those people are because they've been staying home already, or they've been expressing concern that they have to stay home. I'm a single mom. My school, my kid's school got closed. I can't come to the office. If they can telecommute from home and take care of the kid at the same time, then more power to them. They wouldn't need a leave. Okay. Employees must have 30 days of service to be eligible for this particular expansion on the leave. So again, under normal FMLA conditions, it would require 1,250 hours and 1 year of service. For this particular type of leave, it only requires 30 days of service to be eligible. Okay. Now, this is a paid leave, but under the EFMLA, the first 2 weeks are unpaid. But remember, the first 2 weeks are to get paid under the EPSL. So I don't know why they wrote it this way, but basically they said, hey, you can get up to 80 hours for the emergency paid sick leave under reason number 5, which is the school closure. So the first 2 weeks are unpaid under EFMLA, but they're paid under EPSL. How's that for confusion? And then after the first 2 weeks, the employer must pay 2/3 of the regular rate of pay, not to exceed $200 per day. And it says 10,000 in aggregate, but really it's 12,000 because you've paid 2,000 under the EPSL. Okay. You want to designate the FMLA leave as you would any other FMLA leave, meaning you should have a form filled out. They request the leave, you determine whether they're eligible for the leave, and then you're going to tell them the terms and conditions that the leave applies. The group healthcare benefits, if you offer them and the employee is already covered, must be continued while they're on a leave of absence. You can require them to pay the amount that normally would come out of their paycheck, but you cannot cancel their insurance while they're on a leave. As far as documentation goes, you're going to want them to provide a signed statement that says their name, the date for the leave that's requested, the qualifying reason for the leave, and then a statement representing that they cannot work or telecommute. If the employee is taking leave for his or own serious medical condition, then you can request the usual medical certifications. But again, the reason for the expanded leave is specific to the school. So they would, if somebody came to you and they were sick, they've tested positive, they need to go out on a leave of absence for their own serious health condition, and you're already subject to FMLA, that's what the second bullet's for. So it's specifically if somebody is sick, they're eligible for FMLA under normal circumstances, then treat it like a normal FMLA leave. Okay, there are a couple of exemption possibilities. One is if an employer has fewer than 50 employees. Now, the exemption only applies with respect to providing the benefits due to the school closure. There's some very specific reasons. Basically, they're trying to define hardship, and it's a very specific hardship, right? So if somebody comes to you and they say, I've got to stay home, take care of my kid, I need, expanded FMLA, there's no way I can telework or anything like that, and you say, wow, our organization wouldn't be able to operate without this person, right? We couldn't even just maintain because of their skills or their knowledge, things like that, you might be able to get an exemption. There is no way to quote unquote apply for that exemption. The government does not want you filling out forms and sending them in or applying or anything like that, so don't bother. They're saying you basically self-determine whether you think that it's a hardship exemption, and if it is, document the denial of the leave and then hold on to it. And essentially what they're saying is, we're okay if you think that your hardship, that's fine, time will tell if somebody ever challenges you, right? So how it would show up is an employee is going to say, hey, they denied my leave. They go to a lawyer, something like that. And then you're going to have to prove that you think you fall under one of those exemptions. So just tread lightly on that one. And then also healthcare providers and emergency responders may be excluded if the employer wants to take that approach. We do have some clients ourselves that run urgent care clinics as an example. She wouldn't operate if anybody, if people that were healthcare providers were obviously taking the leave. And so she is choosing to exempt her employees from that. Okay, there are tax credits I mentioned before. I'm not a CPA, but my understanding is that you can claim dollar for dollar payroll tax credits for any monies paid out under the FFCRA. The details on how to obtain those credits should be released in April. We haven't seen them yet, and credit will only be received for payments made beginning April 1st. So if you were one of those really kind employers that continue people's pay during the month of March, just know that you're not going to be able to seek tax credits for that unless something changes in the final regs. Okay, I think this is the last slide with content, and then I'll take some questions. So the FFCRA was the first act that was passed. The CARES Act was signed into law, I think it was a week ago Sunday. And this is the Coronavirus Aid, Relief, and Economic Security Act. It was a $2 trillion act that provides subsidies and expanded unemployment insurance benefits for individual workers, and then various forms of financial assistance for employers, okay? Here are the two different types of loans. So the first bullet on the employee benefit, this is where certain individuals who are already collecting unemployment will receive an extra $600. I believe it's up to $75,000 in, if you make $75,000 or less, you're entitled to that. I don't know how or when those checks are going to be issued, but that's what I believe was part of that. I'm just going to focus on the employer part of this. So the types of loans, there's two different types. On the left-hand side, you see the EIDL loan, the economic injury disaster loan. You actually, as an organization, can go online and apply directly at sba.gov/disaster. It can be used for operating expenses, other final obligations, because you need money that otherwise you would have been able to take care of your debt, of your, whatever you need to pay to run your organization, except that you can't because of COVID-19. For nonprofits, the interest rate's 2.75%. You can have up to a 30-year term, right? There's no loan forgiveness on that one, and you will have a collateral. They'll take a lien on business assets. Contrast that, so that's available on the one hand with the SBA Paycheck Protection Program, or P3. I would strongly urge all of you to get with your bank right away, and if you haven't already done so, to apply for this type of loan. This can be used to cover payroll for 8 weeks of payroll. It's a 1% interest rate with a 2-year term, and I believe there's like a 6-month deferment on the first payment. What they want to do and why this incentive exists is they want to keep your employees employed. Okay, so there's no collateral, and there may be 100% loan forgiveness. Okay, now the way the forgiveness will work, more or less, again, I'm not a banker here, is that they want you to maintain your employees' hours and salary, your full-time status through June 30th. So if you took staffing reductions already, but you hire people back, then they're going to forgive the loan. If you maintain your staffing levels, they're going to forgive the loan. It is truly like a free money program. The government is essentially paying your payroll for you through June 30th, or for 8 weeks between now and June 30th. So the way you get that is through your bank. Most of the bankers I know are telling us they're only working with people, existing clients on that. So you all have a bank, go to your banker, find out if you're eligible for this program, and apply. The other thing to know about that program is on Friday of this week, they're opening the program up so independent contractors and self-employed individuals can apply. So you want to get your application in before Friday if possible. And that's it. This is my slide. I just want to draw your attention to a couple links at the bottom. Again, don't know what's going on with the link there for the slides, but I will make sure that you guys get that. And on our Ethos website, we do have important COVID-19 information. So we have some links there for you. So if you go to ethoshcs.com, you'll find that. It also has links to our prior emails and our guidance we've given employers. There's helpful links. And then you can also join our mailing list right there if you want to continue to get our emails going forward. Kevin, any questions?
Yeah, Linda, first, we just want to say thank you so much. That's a lot of information and super helpful. I'm sure everyone will reference this. Well, again, we'll be sending out this presentation to you guys. I've been recording it. So if you need to go back and look at certain things or review, that'll be available. We did get the link to the slides to work.
Yeah, I was going to say it worked for me. So
Yeah,
yeah, sorry about that.
so like the back end of the URL was compromised, but we got the URL that was on your first slide and that worked. So that
Okay. All right, great.
Couple questions that came in surrounding FMLA or the new FMLA
Yeah.
is, are you aware of a matrix available to determine eligibility for EFMLA, or like an eligibility tree to kind of dissect if your employee qualifies?
So for the EFMLA, there's only one reason, right? And that is that they cannot work or telecommute because they have to stay home to take care of a child whose school or childcare closed due to COVID-19. Okay. In California, or at least in Orange County, our schools have been closed for 3 or 4 weeks now. I would think that you would know if somebody is like a single parent, or they're struggling to take care of kids or something like that, or maybe both parents work, so someone has to stay home with the kids. So all I can say is you can only push so hard, right? If somebody says, hey, I can't work, like the example I gave before for our one client, she's been trying to telecommute at home, and she's got a 1-year-old and a 5-year-old. It's just really hard on her. Now, this will give her up to 12 weeks of time, to take care of the kids. It's only going to pay her up to $200 a day. And then, that's, maybe that's okay for her. I mean, I don't know how much she makes right now. I don't think there's a big decision-making tree there. They have to have been employed for 30 days, and they have to not be able to work or telecommute because they have to take care of the child.
Got it. Great. Linda, I did put your email in there. If people have specific questions about topics that came up, are they good to email you?
Absolutely. Call me, email me. I'm just trying to help as many people as possible because I know that this is really challenging times. And again, I give you my best advice with the best knowledge I have in any given moment. I feel like this has been very humbling to me. I'm used to like studying everything, having the answers for my clients, and the Department of Labor has a funny sense of humor and just unbelievable timing, because as soon as I hit send on an email, something changes in their guidance, I swear, like 5 seconds later. So we've had to go back to a lot of clients and change our guidance as things evolve. But I will give you my best advice I can.
Perfect. Thank you so much, Linda. And guys, just to keep you in the loop, on Thursday, we're going to be doing another webinar more focused on the CARES Act and the different legislation that's in place with the Public Law Center on Thursday. And the link to that is on our resource page on 10c.org. So feel free to check out and register for that. We'll be going, she is able to give, some legal recommendations. So tune into that. And with that, thank you guys so much for logging in. Again, I'll send this in an email to you guys, or with the link to the recording. And we'll see you soon. Linda, thank you so much. We appreciate it.
All right. Thanks, everybody. Have a great week.